Hi, this is Josh Blackman, and I'm the president of the Harlan Institute. It's my treat to welcome you to match number 5 of the 2018-2019 Harlan Institute ConSource Virtual Supreme Court competition. Today we'll be arguing the case of Timms versus Indiana, and we have a shorthanded bench today, but we'll be joined by a team from Lake Oswego High School. We have Anushka Nair, and we have Lucinda Smith. And I'm joined, as always, by my dear friend and colleague, Julie Silverbrook from ConSource. Julie?
We are excited to start our 5th round, and I wish both of our petitioners the very best of luck as they begin their argument.
Okay, very good. So I believe, Anushka, we need a primary argument. You have 15 minutes. You can begin whenever you're ready. And I believe, actually, the other team just joined.
Okay.
There you are.
Yeah.
Wonderful.
In the nick of time.
Computers and multiple counters. We're here.
Okay, well, we now have the respondents as well. You narrowly avoided a forfeit, but you're here. We have Grace Cook and Emma Winter from Lake Oswego. We didn't begin yet, so all fair. If you, Grace and Emma, please put your microphones on mute for now.
Okay.
If you just click the little mute button on the microphone.
Oh, yeah.
Okay, great. Okay, so Anushka, you have 15 minutes. You can begin whenever you're ready.
May it please the court that I, Anushka Nair, and my partner Lucinda Smith will be representing the petitioner, Mr. Tyson Timms, in the case Timms v. Indiana. The question presented is whether the 8th Amendment's excessive fines clause should be incorporated against states under the 4th Amendment Privileges and Immunities Clause or the Due Process Clause. First, let's move on to the facts of the case. The court focuses on the government's excessive fines of $42,058.30 of a Land Rover that was used to transport heroin between Richmond and Marion, Indiana by Mr. Timms. Timms had paid this Land Rover with the life insurance money he had gotten. This was seized by the government as a fine when he was charged with 2 counts of dealing a controlled substance and 1 count of conspiracy to commit theft. When he pled guilty to 1 count of felony dealing and 1 count of felony conspiracy to commit theft, he was charged over $1,200 in fees and court costs, even though the maximum fine in a statutory Class B felony was $10,000, making it so Timms had paid over 4 times the amount of a maximum fine for that case. We propose that the excessive fines clause is incorporated against the states under the Privileges and Immunities Clause and under the 4th Amendment instead of the Due Process Clause. This is based on 3 major arguments, the first of which is the historical context on the basis of the Privileges and Immunities Clause. The Privileges and Immunities Clause and the case of the Bill of Rights started with Barron v. Baltimore, a case where the Bill of Rights was said to exclusively only apply to federal protections, not state governments. This was again followed by the Slaughterhouse case, where the 14th Amendment privileges and immunities was started to be used as a method of incorporation. Yet the Slaughterhouse cases eviscerated it by saying the 14th Amendment Privileges and Immunities Clause applied exclusively to the federal government. This was based on the fact that there was repetitive language in both the body of the Constitution Privileges and Immunities Clause and the 14th Privileges and Immunities Clause, making it so the citizens of the United States of America would be under the 14th Amendment, while the states would be under the Article 4 of the Constitution. This was followed then with U.S. v. Cruikshank, in which the court reiterated that the rights of this case could not be incorporated under privileges and immunities because it only applied to federal governments. This was further instituted by Saines v. Roe, a case in which Privileges and Immunities Clause was reduced only to travel.
So, Counselor, if I could just interject for a moment, are you asking us to overrule Slaughterhouse and Cruikshank?
We're asking that the method of which Slaughterhouse, yes, because the 14th Amendment should not only be applied to federal governments based on the original intent of the argument, and on that case, U.S. v. Cruikshank that follows that would also be something to be overruled.
So Counsel, let's just talk a minute about, you're asking us to overrule precedent that's about 150-something years old. How do you understand the concept of stare decisis?
Sorry, could you repeat? I think you're good. Sorry.
I'm sorry. How do you understand the concept of stare decisis?
So the case, so court rules based on previous precedents, but in this case, the originalist intent before Barron v. Baltimore, the Slaughterhouse cases, U.S. v. Cruikshank, was completely different than how the court instituted the Privileges and Immunities Clause, and the evisceration was not based on original intent.
Counselor, I want to probe you a little bit on that. So the question is, why do you think slaughterhouse is a departure from the original intention of those who drafted the Privileges or Immunities Clause of the 14th Amendment?
Okay, yes. So in the Articles of Confederation, which was the first mention of the Privileges and Immunities Clause, the Articles of Confederation were created to limit federal jurisdiction over states because Congress couldn't regulate commerce or limit internal state policy. And that's a completely different intent than the 14th Amendment, which was created during the Civil War Reconstruction era and was used as a method of aligning the legislative process with racial equality. So at this time, there was black codes, and the Civil Rights Act of 1866 was created in order to stop states from creating protections that valued one race over the other. But legislators were wary of this process and the ability to pass the Civil Rights Act of 1866. So the 14th Amendment was created as a way of constitutionalizing that act. And the Civil Rights Act of 1866 relied on Congress's ability to pass the law, and it was decided to be enforced through the message. So as John Bingham says, the body of the Constitution's Privileges and Immunities Clause and the 14th Amendment Privileges and Immunities Clause have completely different basis, yet we have conflated those two accidentally in an effort to say that Saines v. Roe, which applies more to the bodies of Constitution, in which it states that every person may have free ingress and regress out of the state, that was meant as a method of travel, as a method of incorporating the ways the federal government can regulate states. But the Privileges and Immunities Clause, original intent of the 14th Amendment, was used for racial equality. So the way we ruled, we conflated two different—
Well, how do you know that, Counsel? How do you know that? So what kind of evidence can you cite to us about the original understanding of the 14th Amendment's Privileges or Immunities Clause? What evidence can you give us?
Okay, so the Privileges and Immunities Clause of the 14th Amendment was first mentioned way back in the beginnings of our country. So the terminologies privileges and immunities were commonly understood to refer to rights. So in the decision of the Slaughterhouse case, the court chose to ignore legal precedent of the defining of privileges and immunities that was defined in Corfield v. Corwell, where Justice Boshred Washington's circuit opinion defined privileges and immunities as in their nature fundamental, which belong of rights to the citizens of all free government, and which have at all times been enjoyed by the citizens of the several states which compose the Union from the time of their becoming free, independent, and sovereign. So the fundamental definition was the Bill of Rights protection. This also goes even farther back, when in the medieval times, both terms were used to define legal benefits granted by the special grace of the king itself to particular individuals. In dictionary definitions of the Independence Institute, Professor Robert G. Nelson wrote that a privilege is a benefit or advantage referred to a positive law on a person or place, or contrary to what a rule would be in the absence of a privilege. So this all shows that these rights were originally thought to be synonymous with the rights enumerated in the Bill of Rights. It goes further with the Magna Carta of 1215 and the English Bill of Rights of 1689, where, as legal scholar William Blackstone writes, the privileges and immunities of the English citizens were rights themselves defined by several statutes, consist of a number of private immunities, which will appear from what has been premised to be indeed no other than either that residuum of natural liberty which is not required by laws of society to be sacrificed for public convenience. So in this state, the phrasing of privileges and immunities was then taken from the English Bill of Rights and the Magna Carta to multiple colonial charters, one in Charter of Maryland and another in Georgia post-Civil War that we previously cited, and many, many others. And this historical documentation just demonstrates how privileges and immunities were both phrases used often interchangeably with rights, and those slaughterhouse cases did give them separate meanings. The use of the word now tends more interchangeably. Furthermore, the colonists, from the English citizens of Magna Carta to colonial charters to state constitutions, and then the privileges or immunities guaranteed to colonists in the same rights in the Bill of Rights, these were the same rights that were taken from the rights that they once possessed as English citizens. So this constitution was later amended with the creation of the Bill of Rights to protect those same fundamental rights. So with that interpretation, the privileges and immunities of the United States, rights from the United States, privileges and immunities of the citizens of the United States are a parallel fundamental right to those translated from colonist citizenship to England, which are now protected by the Bill of Rights. As John Bingham, the creator of the 14th Amendment, once wrote, he supports the interpretation that the privileges and immunities of the citizens of the United States are chiefly defined in the first 8 amendments of the Constitution of the United States. So with this phrasing, our phrasing of the Privileges and Immunities Clause of the 14th Amendment states, no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States. Privileges and immunities, as we have talked about, has both been defined as a synonym for rights. So with this substitution, the amendment now states, no state shall make or enforce any law which shall abridge the rights of the citizens of the United States. As the Bill of Rights was a document created in order to delineate the rights afforded to United States citizens, the amendment would now read, no state shall make or enforce any law which shall abridge the Bill of Rights. So
your argument that under the Privileges or Immunities Clause, these rights only apply to people who are citizens of the United States?
So the argument is that under the Privileges or Immunities Clause, the Privileges or Immunities Clause is meant as a protection for the Bill of Rights. And the Bill of Rights, the creation of the amendment was the creation of the amendment was meant as a way to incorporate these rights to states. So the Bill of Rights was the same protection, and the Privileges or Immunities Clause was meant as a method of incorporating those Bill of Rights to state citizens from federal citizens.
Right, but under your interpretation, if we were to diverge from what we're currently doing, I have a question about that too, of using the substantive due process clause to incorporate against the states, and we transition to privileges or immunities, how are we going to deal with the fact that the Privileges or Immunities Clause has this citizenship language in it? So it only apply now. All of a sudden, the Bill of Rights only applies to U.S. citizens, that you wouldn't afford any rights to people who were not U.S. citizens? Help me understand
that. So under our interpretation, the Bill of Rights, the Privileges and Immunities Clause, and the Bill of Rights would be interpreted to only citizens of the United States of America. And in that case, when we're talking about substantive due process, we would propose to split the substantive rights to be on the basis of Privileges and Immunities Clause, and for procedural rights to be protected by the Due Process Clause. So it'd be a two-pronged protection of incorporating the Bill of Rights to the state.
And how do we distinguish between those two things?
Okay, so for after the evisceration of the Privileges or Immunities Clause for the Slaughterhouse case, the court looked for alternative ways to protect fundamental rights. And as Professor Harry P. Tepker argues, the Supreme Court rejected the idea that privileges and immunities could be used as a way of incorporation after the Slaughterhouse cases. So due process started to become a method of substantive due process. So in cases where Paco v. Connecticut, in cases of double jeopardy, or Lawrence v. Texas and Roe v. Wade, which were both cases of personal privacy, due process started to become the method of protecting substantive rights. But as Justice Thomas talked about in his opinion, he states that this is an indulgence of the Due Process Clause, and it overreaches its textual protections. So in like cases such as Brooks v. Brady, which is a case about procedure,
Counselor, let me just pause you for a minute. Justice Thomas in McDonald was willing to use the Privileges or Immunities Clause. He was alone. Everyone else in the court thought not. Why should we go down the Justice Thomas road when he was the only justice advancing this position?
Well, in McDonald v. Chicago, Justice Thomas also cites historical basis and originalist intent. And he also talks about how right now due process is being used outside of textual protection and going into legal fiction. So when we use due process for substantive protections, we're going outside the basis of original intent. Also, as many justices stated in the previous opinions, the due process, the appeal of it is that we have more flexibility in deciding decisions. Yet flexibility also leans itself to decisions being decided more on opinion than legal basis.
No, I get that. I mean, Justice Silver, go ahead. I'm sorry.
I just want to go back to so you're going to allow for substantive due process to be used on rights that you say are more procedural in nature, and then privileges or immunities are for more rights-based. But at the same time, you're saying there is a citizenship requirement attached to one and not the other. How do you justify that difference?
So the citizenship requirement attached to the privileges and immunities is what we're arguing is, I'm sorry, I'm really confused. So for the Bill of Rights protections, we argued that the privileges and immunities clause should be a method of incorporating the Bill of Rights. So I spoke wrong. There shouldn't be a citizenship requirement attached to the privileges and immunities clause, but the Bill of Rights, so which the privileges and immunities clause can incorporate that dual citizenship of the citizens of the federal government to the citizens of the state's governments.
Okay, so then when we're talking about the privileges or immunities, I think it's national citizenship, you're arguing that that doesn't mean it only applies to people who are U.S. citizens.
Yeah.
Okay, so we're just ignoring that language.
Yes.
Okay, and why? Right, you're relying a lot on original intent in your argument. Do you have evidence from the time period in which that was written?
And I'm sorry, about 40 seconds left, so answer the question and then we can move on.
Yeah.
Okay, yes. So based on the ways the originalist intent was this was created in an age of freedom of slaves. So the method of citizenship at that point was quite loose based on state interpretations. So the method that was created for states was to say that if you are a freed slave, you have the same protections under which a citizen does as well. So as as the speaker said in the Black Code violations and in the Civil Rights Act of 1866, many say that there needed to be
okay, counsel, you're out of time. You can finish your sentence.
Okay, that's fine.
Okay, thank you very much. Okay, thank you very much. Anushka, please put your phone on mute. And now we will turn to the respondents. Grace and Emma, please take your microphone off mute. Okay, and you have 15 minutes. You can begin whenever you're ready.
Thank you very much. May it please, honorable judges of the court, my name is Grace Cook and I'm representing the respondent, the state of Indiana. In June 2013, Tyson Timbs was arrested in the state of Indiana. He was accused of 2 counts of dealing drugs and 1 count of theft conspiracy, much as we've already addressed. I very much agree with the summary of the facts that Anushka has laid out, so therefore I am going to move beyond this. It is well established that the maximum fine, or the car was much above the maximum fine, so this fine should have been prevented. However, it was not prevented because the excessive fines clause has not been incorporated. We find that the excessive fines clause should be incorporated using the due process clause, and it has long been acknowledged that the protection against excessive fines is very important. We again would like to cite the English Bill of Rights of 1689, where the authors lamented that excessive fines have been imposed and stated that this, along with their various other grievances, were utterly and directly contrary to the known laws and statutes of the freedom of England. So to set some precedent for our United States laws. This history further proves that the protection of the citizen against excessive fines is fundamental to a scheme of ordered liberty, which is the standard that has been set in Palco v. Connecticut for incorporation to the states. So thus, this right must be incorporated. While the privileges and immunities does not and should not incorporate the 8th Amendment, due process does. Following the slaughterhouse cases in 1873, it was deemed that privileges and immunities are not the correct avenue to incorporate rights, that they were only intended to assure that African American citizens could obtain their rights equally and fairly. And this is from the intent of the 14th Amendment as it was written. Privileges and immunities has thus become useless in defending citizens against the state government when it has come to these rights. And due process has been the tradition set for incorporating all the rights that have been. Switching to using privileges and immunities for excessive fines would change the intent of that clause.
I'm so sorry. Let me interrupt you for a second.
Yeah.
How do you respond to counsel on the other side who says actually the entire body of substantive due process jurisprudence that we have is really at odds with the original intention behind the 14th Amendment.
I find that to be incorrect. When you look at the history and the intent of the 14th Amendment, it was written during this time of civil rights, so clearly is intended for all of the Privileges and Immunities Clause specifically included within that is intended to apply rights to that newly freed slave community. I also find that we should not overturn the slaughterhouse cases in any way. I think with the idea of stare decisis, the precedent should hold and needs to hold in order for our justice system.
But I still want to go back to this original point, right? Other than, give me some evidence, right, from the 14th Amendment's, drafting period and ratification period that support that we should not be using the Privileges or Immunities Clause to apply, federal rights under the Bill of Rights to the states. Or look at case law. How did we arrive there? How did we arrive at our substantive due process jurisprudence, aside from the ruling in Slaughterhouse, right?
So, aside from Slaughterhouse, I'm just referencing notes quickly. The reasoning why the Privileges and Immunities is only to protect this specific class is because that was at the time of the creation, that was the class that the amendment was created to protect. It was not created to protect. I guess I'm kind of rambling here, but it was not created to.
Let me give you a different question.
Okay.
So, how do you respond to the argument that it is unusual or even improper to use the due process clause to incorporate rights that are not procedural in nature?
I find that the use of due process very much works in this case, though the right itself of not having an excessive fine is substantive. The whole thing of substantive due process has been created because the way in which it'd be enforced is a procedural requirement. So, which would fall under due process through the court system's actions of fining. That's the procedure. So thus we can use due process to say that that is not a thing that should be allowed. So that's where, that's following the logic to create the substantive due process, where it takes it from being what seems very much a substantive right to being able to apply due process in order to have that civil liberty protected.
Okay.
And protected against the government.
You can continue with your argument.
Okay. I would also like to state that I don't find, along that same line, I do not find that a two-pronged approach, much like my opponent has proposed, would be an accurate way to do this. I find that due process is the correct way to incorporate rights. And you also had brought up citizenship as a question. In the text of the 14th Amendment, it states that no state shall make or enforce any law which shall abridge the privileges and immunities of citizens of the United States. So that citizenship is accompanying privileges and immunities. However, in the due process clause, it says, nor shall any state deprive any person of life or liberty or property without due process of law. So through using the due process clause, we are also able to ensure that these rights are applied to any person instead of purely to citizens of the United States, which also, or states specifically, which also allows these rights to be applied throughout. Instead of saying, let's say you're a citizen of Oregon and you go to Washington, you will still have rights. And if you're, yes, I'm sorry, that's, so I find that with the textualist argument, the language leans much more towards due process in that statement as well. I also find that so as I was saying earlier, switching to using privileges and immunities would change the intent of the clause, and it would also discredit precedent, which is an idea that is very important, obviously, to our justice system, and that should be upheld. The Due Process Clause initially was created to protect citizens from broad unconstitutional action, so it should continue to have this purpose, and so thus precedent holds that the excessive fines clause should be incorporated through the Due Process Clause of the 14th Amendment, much in the way that I described of substantive due process. And some cases, all of case law since Slaughterhouse of incorporation has used due process to incorporate those rights, such as Chicago v. Burlington and Quincy Railroad versus Chicago. Those both argued that due process does protect against state violation of the Fifth Amendment. In Gitlow v. New York, they used due process for free speech. In Neer v. Minnesota, again, due process for free press. And then Palco v. Connecticut, as I already mentioned, which created the standard for further incorporation.
Counselor, can you talk a minute about how the court should respond to the argument that Slaughterhouse was wrong as an original matter? Right? How should the court respond to that sort of argument?
I think that while that may be an interesting argument for academia, in the place where we are today with making further court decisions that we need to hold with precedent, it was very interesting to listen to my opponent's arguments, but I don't find that that is an issue for further litigation. I think that we need to hold with using due process.
Okay, thank you, Counselor. You may proceed.
Okay.
And you have about 4 minutes left.
Okay. I think that it was just the large thing that I would like to emphasize is that due process should be the way that we incorporate this, obviously, because it's because it holds. Also, I would like to cite Justice Miller's majority from going back to the Slaughterhouse cases. He interpreted the 14th Amendment very narrowly, and this is some citation for the intention of the 14th Amendment. He states that they meant the freedom of the slave race, the security and firm establishment of that freedom, and the protection of the newly made freedman and citizen from the oppressions of those who had formerly exercised unlimited dominion over him. And that's a textual quote from his majority, further backing up that privileges and immunities is not to be used for the avenue of incorporation. And I think this issue of intent of the amendment and of that clause specifically, is, along with precedent, holds that it should not be used. And then also, should the 8th Amendment excessive fines clause be applied to the state, the scope will follow the precedent that has been set by past cases of selective incorporation, such as the incorporation of the just compensation clause of the 5th Amendment. And in the case of Chicago, Burlington, and Quincy Railroad versus City of Chicago, in 97, this marked the first time of selective incorporation, much like we would be doing in this case. And once again, that is setting a clear precedent for using the due process clause of the 14th Amendment as the means of incorporation. And in addition, the legal forfeiture of his vehicle very clearly amounts to an excessive fine. As opposing counsel has stated, it was more than 4 times of the maximum fine. So the forfeiture of this vehicle warrants or shows the need for the incorporation of this clause to the states, that it is a necessary protection, that it is necessary for the scheme of ordered liberty, and that satisfies the standard that has been set in Palco v. Connecticut. In addition, we find that civil forfeiture is an unconstitutional punishment as a whole, due to the fact that there doesn't have to be evidence of wrongdoing that his car was taken in a civil suit rather than as a punishment in a criminal suit, and this, which directly violates due process because it's seizing property without the correct protections for his charge, because it was much more than the maximum fine, the valuation of the property that was seized.
You have about a minute left, Counselor.
Okay. I would just like to thank the court and once again remind that both history and case law back up that the due process clause should be the mode of incorporation for the excessive fines clause in this case, and that the due process clause should hold, and we should not overturn Slaughterhouse and any of the decisions made within.
Great.
Okay.
Thank you.
All right, very good. Thank you so much. Okay, Emma and Grace, please mute your microphones.
All right.
Thank you. And we'll go back to Lucinda, and you now have 5 minutes for rebuttal, and you can begin whenever you're ready.
All right. Hello. Thank you for listening to our side of the case. And you've heard the facts from both sides, from the petitioner and the respondent. Although we have different opinions, we can both agree on the fact that he was charged with excessive fines. But how is this incorporated? The respondents argued about the Slaughterhouse cases and that although they do set precedent, it's still a time of changing and we have to adjust them. And the Slaughterhouse cases were at a time when there was still heavy racism and it was very difficult for African Americans to have rights. And that now we all have equal rights in America. And now the idea of privilege and immunity needs to follow the general trend of the Constitution, which is covering everybody. This cannot just cover the Slaughterhouse cases and the privilege and immunity. It cannot just cover everybody who is now on American soil.
But hold on, Counselor. What's the argument that the Privileges or Immunities Clause applies to citizens and non-citizens alike? Can you just walk me through that one more time, please?
Sorry, could you repeat the question?
What's the argument that the Privileges or Immunities Clause protects citizens and non-citizens alike? Can you walk me through that argument?
Oh, because I'm just showing we're all on American soil, so we all fall under that blanket and have rights when we enter the American property.
Right. But let's look at the text. The text applies to citizens, right? There's no state shall make a law that bridges the privileges or immunities of citizens of the United States. It doesn't apply to those who are on U.S. soil. It applies to citizens, I think, at least. Well, what's the argument to the contrary?
Well, when you enter the United States of America, you are now under a certain protection, not necessarily entirely just from where you came from. You also have to be underneath American soil as well, and ideas of the United States.
All right, you may proceed, Counselor.
Okay, thank you. well as an argument that I would like to, the main argument that I'd like to address is, of course, that they're arguing that it should be through the due process clause, while we are arguing that it should be through privileges and immunities. And they continue to mention that it should be a they mentioned a little bit about it being procedural, and we would more on the substantive side, because the procedural would go over the exact procedure of how he was charged, and that would there be a lack of case in that situation. And so by arguing substantive, it is how the fine is carried out. Mr. Timms could still be tried, but it's the fact that he's charged with this excessive amount. As well as they also mentioned that they should not obtain civil forfeiture is unconstitutional, which, yes, it's not nice to have your things taken away, but because it was a vehicle, he could have easily driven away with the evidence. And so by taking away the car, they prevent that from happening. And to continue reiterating the point of my partner, it is definitely leaning towards the more legal fiction ideas. And although Justice Thomas stood alone on his opinion, it doesn't necessarily mean that his opinion is wrong. And initially, not everybody has to agree with him either. But with this idea being said, at our side, the petitioners are choosing to follow the original intent of the Constitution and the original ideas of the people at the time. And as we've talked about in all of the privileges and immunities clause, that everybody has the same rights and they should not be abridged. How much time do I have left?
Okay. You have about a minute left, but 50 seconds.
All right. Well, although the respondent did bring up some excellent points, as petitioners do truly believe that the privileges or immunities clause should be used in order to incorporate the rights of the Eighth Amendment. Thank you for hearing our side and listening to both sides as well.
Okay. Thank you so much. Okay. Petitioner, please put your microphone on mute. And respondents, please take yourself off mute. Okay, and you can begin whenever you're ready.
All right. Hello, Justices. So I am the rebuttal for the respondent. We just want to start out with saying that our opponents seem to have a clash of understanding on how due process and privileges and immunities work, while Ms. Nair has an understanding of a textual evidence and a textual argument. Ms. Smith seems to have the idea of an evolving standard. So we just really don't know how solid that argument is between the two of them. We also would like to express that the historical context of privileges and immunities is used to protect the rights of African Americans in voting rights, whereas the case we are presented with today has nothing to do with voting or race. While the reason we can't overturn due process and the slaughterhouse cases is we've had so many cases that have been determined on the basis of due process, and we would be overturning all of those really important cases. Let's see. Also, we'd like to say that privileges and immunities is not used to protect the broad rights of the citizens. They're only used to ensure the rights of the slaves. However, due process is said to protect the life, liberty, and the pursuit of happiness of all citizens from the governments and the state government. And so I feel that it would be best to incorporate the Eighth Amendment via due process, since it's a broad way to interpret this law. Okay.
About 3 minutes left.
Okay. We find that citizenship to be paramount because it also protects non-white non-citizens too. And I feel that if we use privileges and immunities as a protection against law, we are going to be losing a lot of protecting elements from our state government. And when using due process, we are able to protect more rights and not just voting rights and civil rights. We're allowed to protect citizens from, well, like freedom of speech. We allow that, and if we use due process in this case, we will be allowed to use the due process to protect state citizens from the state's excessive fines clause. Well, and also due process we see reaffirms via Slaughterhouse the traditional balance between federal government and the states and this power. Because if we incorporate the Bill of Rights to the states via due process, we are technically giving them the same amount of, the citizens, the same amount of protection. Yeah. Okay, and so something also really important that we must address is the scheme of ordered liberty. The standard for this states that the standard for incorporation should be due process in Palco v. Connecticut. And
about a minute left. About a minute left, Counselor.
Okay, perfect. So anyways, honorable justices of the court, we would like to say that privileges and immunities is not a viable way to incorporate the Eighth Amendment because of its very narrow interpretation and for its voting protections and civil rights protections of the African American community. Okay, thank you.
Okay, thank you very much. Just put your microphone on mute.
All right.
Okay, well, this brings match number 5 to a close. I want to thank both teams. You did a wonderful job. It seems every week we go to new levels of performance, and we're all very proud of you. We make our decision the next week or so. So I very much appreciate the time that you took on this week to come out to us. Julie, is there anything you'd like to add?
To reiterate, congrats on making it this far, and in your performances this afternoon, you should be proud of how prepared you were and how much work went into writing the brief. And I would just say that I hope all of you will continue to hone the skills that you started to develop through this competition. So public speaking, persuasive writing, and persuasive argument. I hope you all stick with it. And I know with your teacher, you will. So congratulations again. And again, we will be in touch soon.
Okay, and with that, I will bring this round to a close. And for my friends in Oswego, we'll call you back in about 10 minutes or so for the final round. Thank you all so much.